Hello and welcome. I'm Amritan Rai and you're watching Law of the Land on Rajya Sabha TV. Today we will discuss why the Supreme Court struck down the National Judicial Appointment Commission. To discuss the issue, I have with me Mr. V. Giri, former judge, Kerala High Court and senior advocate of the Supreme Court. Mr. Rakesh Dwivedi on the OB van, senior advocate, Supreme Court. But first, the headlines. The Supreme Court strikes down the National Judicial Appointment Commission law, terms it unconstitutional. The Supreme Court and High Court judges to be appointed through the old collegium system. The Apex Court says appointment of constitutional authorities cannot be vetoed by political representatives. The Supreme Court of India has struck down the National Judicial Appointment Commission law. The law was passed by both houses of Parliament unanimously. The court has directed that appointment of judges for higher judiciary will be made through the collegium system, as was being practiced till the government created the Judicial Commission.
The Supreme Court ruled that the 99th Constitutional Amendment and the NJAC Act are struck down as unconstitutional. Pre-existing scheme of appointment of judges stands revived. With these words, the 5-judge Constitutional Bench of the Supreme Court struck down the 99th Constitutional Amendment Act with majority view. The court said that a constitutional authority like Chief Justice cannot be vetoed by a political representative while appointing judges to higher judiciary.
The law minister and the leader of opposition may sideline the siege of India in a particular case, in the matter of appointment of eminent persons. They may group together, and CJ is a stranger to them. He's not a politician. You don't have any connection directly with the people. He is responsible only to the constitution, and to the people of this country as a whole. So far as politicians are concerned, whether it's a law minister is representative of a particular party in power, leader of opposition is the leader of the largest party in the opposition. So it's possible in a given situation, these two persons get together and they can sideline the CJI.
According to the judgment, the National Judicial Appointment Commission damages the basic feature of the Constitution. The judgment says that changes made in Article 124 of the Constitution empowering Parliament to regulate the procedure and manner of selection of judges of Supreme Courts and High Courts is unconstitutional. The court said that primacy in appointment of judges must be with the judiciary to ensure independence, and predominant role of executive is not permissible. Court has also said that government, which is a major litigant in the country, and to appoint a cabinet minister to participate in the actual selection of a judge of a High Court or of the Supreme Court is extremely anomalous. The court has struck down the 99th Constitutional Amendment Act that has changed Article 124 of the Constitution to allow the appointment of judges through National Judicial Appointment Commission Act with immediate effect. Court has decided to review the working of the existing collegium system and listed it for future hearing.
This judgment itself is unconstitutional. The collegium system is not provided in the Constitution. It is a creation of the judges themselves. So, if the judges are not lawmakers, and they can only uphold or strike down a law of the Parliament. They cannot substitute the law of Parliament. Collegium system is a substitution done by judges.
The court's judgment came after Supreme Court Advocates on Record Association, SCAORA, and several other parties contended that Government's Amendment Act was hurting the independence of judiciary. Supreme Court of India has appointed a 3-member committee with senior jurist Fali Nariman, Chairman Bar Council of India and Attorney General to review the functioning of collegium system. The committee is scheduled to give their report to Supreme Court by the second week of November. With camera person Ashwini, Rajkamal Rao, Rajya Sabha TV.
The courts are promising to be more transparent as far as judicial appointments are concerned. The Supreme Court has also now thrown open the collegium system to public scrutiny. It has also invited the public views on what kind of persons should be appointed as judges of the highest courts. I'll straight away come to you, Mr. Dwivedi. My first question is, if you can hear me, my question is, substitution of law by the Supreme Court. Do you think the entire NJAC was evolved after 15, 20 years of exercise and recommendations by Law Commission, by the Parliament, huge deliberation, and then both the Houses of Parliament unanimously passed the law, and the Supreme Court goes ahead and quashes it. Do you think Parliament sovereignty has been compromised?
Well, undoubtedly, a very strong democratic element and spirit had gone behind the constitutional amendment and the act made by Parliament. Therefore, the Supreme Court should have, while adjudicating upon its validity, bestowed more respect and deference to it and looked at it from that angle. But there is a bigger problem that with this whole basic structure doctrine. You see that 13 judges' judgment in Keshwanand Bharati, from out of the blue and nowhere, brought in this doctrine of basic structure as a limitation on the power of the constitution makers to amend the constitution. Now, having brought in this gloss, introduced this new concept in the constitution, this is virtually being used by the Supreme Court. In the Supreme Court Bar Association case and SP Gupta case, they gradually overturned the entire Constituent Assembly which framed the Constitution, and from consultation, they have virtually usurped the power of the Parliament. The President is supposed to appoint in consultation with the Chief Justice of India and such other judges.
Correct.
But here what we find is that they started with primacy, then they created collegium of 3 in another case, and then they expanded it to collegium of 5. Where from are they getting all these concepts? I mean, this is just interpretation exercise going on, building upon basic structure. This is rank usurpation of power, and therefore the Supreme Court should have, these 5 judges should have referred it to 9 judges at least to reconsider those cases where they brought in this concept of primacy and collegium.
So most of the lawyers feel that anyway, the moment the judiciary decided not to pass it on to the 9-judge bench, they knew what the judiciary, the judges, the 5 judges constitution bench was going to do. But the point here is, sir...
Absolutely.
So the point here is that they are building on the basic structure, but all in the name of independence of judiciary. They could have easily sent it back to the Parliament for reconsideration, and there were several other options.
No, first of all, the question is you can't go on expanding this independence of judiciary. I mean, Supreme Court is not a completely isolated island away from India. There is a whole constitutional structure in which judiciary interacts. I mean, judiciary has its own role to play, adjudication role to play, but it can't usurp the power of the Parliament to legislate and to amend the constitution.
I'll get Mr. V. Giri in.
And particularly keeping in view the democracy. Democracy is also a basic feature. There are a number of basic features. Democracy is a basic feature. Parliamentary supremacy is another basic feature. So ultimately, judges cannot go on appointing themselves. Where from nowhere in the world this happens.
I'll get Mr. V. Giri in. Mr. V. Giri, what do you feel? Do you think the sovereignty of the Parliament has been compromised by this judgment?
I don't think the argument can be taken to that extreme. It is a law of the country that even a constitutional amendment can be tested. But then there seems to be, and that's what the Supreme Court has held in Keshavananda Bharati and thereafter in Minerva Mills, and recently in the Right to Education Act case as well. That the only way to test a constitutional amendment, which stands on a much higher pedestal than a legislative act, though it is also a legislation, a constitutional amendment is also a legislation passed by the Parliament, and in certain cases passed not only by both houses of Parliament, but also by half the number of the state legislatures, which is what has happened in the case of NJAC. Not that it is required in all cases as such, but it did happen in this case. Therefore, the parliamentary supremacy means that insofar as the Constitution delineates the lawmaking powers or the powers to make law, enact a law, the Parliament is supreme. But at the same time, it cannot be gainsaid that the judiciary has a power to review a legislative enactment, though on much more narrower grounds than how it would review an executive action. When it comes to a constitutional amendment, the Supreme Court itself has said that there seems to be only one ground on which the court can consider whether a constitutional amendment or a provision insertion in the Constitution as such, which is what has happened by insertion of 124A, B, C, substituting 124 as it stood then, as it earlier stood. Does it violate the basic structure of the Constitution? Mr. Dwivedi says, and he is right, that you don't have a definite concept of what is a basic structure of the Constitution because it has not been defined in the Constitution. But you know, there is one thing that you will have to understand, you will have to keep in mind, is that there are certain silences in the Constitution which are as eloquent or more eloquent than what you can read from the text or even the subtext as such. Those silences are also important. It's a dynamic document, it's an organic document, and therefore you will have to understand that a Constitution contemplates that there can be amendments in future. The power to amend the Constitution is given to the Parliament. There is nothing which in this judgment which says that the Parliament cannot undertake the task of.
Correct. So basically what you're saying is that it is still open to the government to start, redo the exercise and bring another NJAC.
Yes, if necessary it can. If it has the political will to do so, it can.
How can you justify that first you create a concept of basic structure and then you start building upon it and build it to such an extent where somewhere or the other there's a feeling that the work of legislation is being usurped by the judiciary?
The work of the legislature has not been usurped. The Legislative Act has been questioned and the court has said, you know, it is not possible to have a completely unipolar view about the judgment. I don't think there will be any person who has read the judgment who completely agrees with the majority or completely agrees with the minority view as such. Point is that if you take away the powers of appointment of the judges completely away from the court, in the sense that the role that is still given to the court is only minimal and not decisive, you are letting in the executive government
to compromise the autonomy
on the
judiciary. Time for a short break. Coming up, appointment of judges to continue through the old collegium system. Welcome back. After Supreme Court quashed the National Judicial Appointment Commission, judges of the Supreme Court and High Court will now be appointed by the old collegium system. The collegium system of appointment allows judiciary to appoint judges without any interference from the executive. But this system has been criticized for its lack of transparency.
Collegium system of appointing judges of Supreme Court and High Courts is derived from the Supreme Court judgment in 1998 after President K.R. Narayanan made a presidential reference. The judgment formulated the memorandum of procedure for appointment of judges to the Supreme Court and High Courts that is being followed for the appointment.
See, the responsibility to find out a best person for the Supreme Court as well as the High Court is the responsibility of the Supreme Court, not the responsibility of the collegium, not the responsibility of the collegium alone. It is a responsibility of all. All I mean the executive, the judiciary, and all persons who are interested in to find out a good person for the system. So you can't say since the collegium has well been restored, that doesn't mean it is entirely the responsibility of the collegium to find out a good person for the post of Supreme Court judge as well as High Court.
According to the collegium system, judges of Supreme Court and High Courts are appointed by the President on the advice of a collegium consisting of judges. The collegium consists of Chief Justice of India and 4 senior most judges of the Supreme Court. The Chief Justice of India makes a recommendation to appoint a judge of the Supreme Court or to transfer Chief Justice of any High Court in consultation with the collegium. The views of the judges consulted must be conveyed to the Government of India by the Chief Justice of India along with his views in writing, and collegium's decision is final.
There is no criteria of seniority. Anyone, any Chief Justice can be picked up and sent to High Court, and a person who has been Chief Justice for 5 years can be ignored, and a person who has been Chief Justice for 5 months can be appointed as Supreme Court judge. There is no criteria how you are measuring the talent of the judge.
The Chief Justice of India is obliged to comply with the norms and requirements of the consultation process in making his recommendations to Government of India. Recommendations made by CJI without complying with the norms and requirements of the consultation process are not binding on the Government of India. Supreme Court's guidelines on appointment of judges through collegium system will act as a memorandum of procedure for appointing judges in higher judiciary. Everyone is hoping that this decision will fill in the vacant posts in High Courts and Supreme Court. With camera person Ashwini, Rajkamal Rao, Rajya Sabha TV.
To bring in transparency in appointments, there have been suggestions to put judicial appointments under the ambit of RTI Act, having a disclosure clause of political membership of appointees and even increasing the number of women judges. My point to you is, Mr. V. Giri, you've been a judge of the Kerala High Court. You have seen the system up close.
To a limited extent.
Yes, but you've been there. Transparency, accountability, and participatory activity. All these 3 points are the biggest, let's say, criticism that is made of the collegium system. They lack transparency, they lack accountability, and it is not participatory. What do you have to say to that?
3 key words: transparency, accountability, and participatory rule. Accountability should take precedence. If 5 persons or 3 persons come together and then decide who's to be, whether A or B or X or Y is to be appointed as recommended to be appointed as a judge, and there were 5 other persons whose names were being considered, and why they chose A over B or X over Y, you can't ask the members of the collegium to say, no, I'm giving you a scale of 1 to 10 and then rate them with specific reference to any objective criteria. It is difficult to assess that. You know, knowledge in law or the fact that you have a flourishing practice by itself may not be decisive of why A should be chosen over B as such. Not that they are irrelevant, they are relevant, but there could be a myriad other factors. How he has conducted himself over the years, how he has committed himself to the institution as such. Whether there could be straws in the wind, but suppose there are any other facets to his outlook on the profession which are to be considered, then they are also to be considered as such. Now, when you say accountability, what you should really insist upon is that whatever be the deliberations that has taken place, you can't say that you should be minuted. That would be difficult, you know. There are certain areas where it will be discussed amongst the 5 members of the collegium, and then they will decide that, no, we feel that it may not be wise to choose A over B, or we feel that it will be wiser to choose B over A. But all the reasons which have gone into the deliberations, you may not really be, I don't think you can really expect them to do that, because you will have to give them the high constitutional functionaries the elbow room to decide which is better or not.
What you're saying is there is a lot of subjectivity attached to the matter.
There is a lot of subjectivity attached to it.
And accountability, transparency and participatory, all these for people to see may not be as easy as said.
It will not be that easy.
Correct. I'll get Mr. Dwivedi in. Mr. Dwivedi, the whole point is the interest of the people of this country. Will it be served if the collegium system is transparent, accountable and participatory in its attempt to appoint judges?
As far as transparency is concerned, it is correct that a large number of factors go into consideration. But then we all know that as in the United States, the Senate virtually discusses the candidature openly. And so I don't see if somebody's name are being considered, then there should be a committee which looks into all objections, filters them, eliminates frivolous objections, and then the person is considered. That is 2. The third is that if 5 or 10 names are being considered, then even though there can't be a hearing, etc., prolonged, it will delay the appointment process, create huge problems. But still, when some judges are being not accepted, then some reasons must be recorded. It is very important to record reasons in the record so that one knows that nobody has been arbitrarily superseded. Okay. As in the case of Justice A.P. Shah.
My question to you is it really possible, the way you've explained it, the way you've said it, the way the collegium system actually functions, is it as easy to implement all this? Can the judiciary or the collegium system...
So there should be no difficulty at all in recording reasons.
That is one. What about participatory, making it more participatory?
Participatory will only mean that those authorities which are recognized by Article 24, they should participate.
Yes.
That's why I said that executive should be in a position to recommend the name, and then the Supreme Court collegium should consider that name with all its primacy.
But after they have struck down the NJAC and the way collegium system is existing, do you think that is possible?
No, that is possible. Collegium system remains, primacy remains, but since President is appointing authority, how do you exclude them completely? They can suggest names. You reject it if you don't find it to be proper.
I get it, sir.
Supposing the executive had recommended Justice A.P. Shah's name, now the collegium of Supreme Court can always consider that name and reject it if they don't find it proper.
Okay.
That is participatory element.
Yes, but now the process of creating or improving the collegium system is on. The government, the collegium, the judges have invited the people to give in their points of view. Do you think that getting the names or getting an executive advisory group to be created under the collegium system will actually be a reality and will be possible?
All that is possible as long as Supreme Court judgment says that their preserve is primacy and collegium. Subject to that, everything is possible even under the existing law.
You would like to add, Mr. Vigri?
I think just taking what Mr. Dwivedi said one step forward, or just to give my own thoughts about it. Even within the existing system, it is quite possible that there could be a more participatory role for the executive. Justice Shah's case is a case in point. Having said that, if you don't choose a senior judge who otherwise comes up to the brink of being elevated to the Supreme Court, and if you don't choose him, you don't mean the collegium doesn't choose him as such. No, it's quite appealing to say that you should specify the reasons as to A, 1, 2, 3, 4 as to why you don't choose him as such. But to say that those reasons must thereafter be posted on the public domain, I don't agree.
Moving on, my colleague Rajkamal Rao spoke to senior advocate Mr. P.P. Rao to get his point of view.
Parliament can make a law constituting a search committee, a broad-based search committee in which judiciary will be represented in ample measure, the government will be represented, the bar will be represented, and 1 or 2 eminent jurists or other eminent persons can also be included in that. But the constitution must be finalized in consultation with the collegium. so that there is no confrontation later on, no scope for further litigation. Once the components are determined, namely representation to the bar, to the bench, to the government, and others, eminent persons. Once these components are agreed to, then the actual constitution of the membership, etc., selection that can be done in consultation with the collegium. So once that law is made, then the search committee will be able to collect data, consider candidates, ultimately make panels of candidates who deserve to be considered by the collegium. So final selection will be done by the collegium. So long as the final selection is with the collegium, there cannot be any quarrel because the primacy of the CJ is maintained.
Thank you, sir, and Mr. Dwivedi on the OB for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.